One.
Hello, I'm Ashley Howell.
And I'm Sheila Holt, and this is our presentation on search and seizure. So the definition of search is to an inspection or an attempt to locate a particular person or object. And a seizure is an action of police in taking possession or control of property or persons. These two items are covered under the Fourth Amendment. In the Fourth Amendment, the Constitution, through the Fourth Amendment, protects people from unreasonable searches and seizures by the government. The Fourth Amendment, however, is not a guarantee against all searches and seizures, but only those that are deemed unreasonable under the law. This amendment is also known as the Search and Seizure Amendment. This means that if the government and government institutions like public schools wants to search your belongings or take them away from you, they must have a good reason to do so, and they must follow the proper procedure. In simple terms, this amendment means that the police can't search you or your house without a warrant or probable cause. What is needed
What is
for
the needed?
What is needed for a legal search and seizure? First of all, you have to have a warrant. A judicial writ or a warrant is a judicial writ or order directed to a law enforcement officer authorizing the doing of a specified act, such as an arrest or a search. They also must have probable cause. Probable cause is a reasonable ground for belief in certain alleged acts. You must have probable cause to obtain a search or arrest warrant. This is the same in public schools. For an administrator or any school official must have probable cause to perform a search on a student. Ashley?
Okay, how does the Fourth Amendment apply to schools? Well, searches by school officials are governed by the Fourth Amendment, but adopts a lower standard for searches than it applies in the criminal context. Specifically, the court only requires officials to have something like a moderate chance of finding evidence of wrongdoing. Public schools need reasonable suspicion to search students. This also applies to testing students for drugs and alcohol. What does it mean to have a reasonable suspicion? Having a reasonable suspicion means that there are reasonable grounds to suspect that a search or test will provide evidence that the student violated a school policy or rule. The reasonableness of any search or test depends on the facts and circumstances of each situation. When can public school officials search or test a student? Public schools are responsible for ensuring the safety of all students. For this reason, public school officials are not held to the higher probable cause standard law enforcement officers must meet to conduct searches. School officials also do not need a search warrant to conduct a search or test. Rather, school officials may search a student or test a student for drugs or alcohol if they have a reasonable suspicion. This applies at school or any school-sponsored event.
So are school searches legal? So when courts try to determine whether a school search violates the Fourth Amendment, they consider a variety of factors. First of all, the evidence for the search. So in most cases, the school must be able to state specifically what they are looking for and have a good reason for believing they will find it in the place they are looking. Second, the item that is being looked for. In general, the more dangerous an item is, the more invasive the courts will allow a search to be. 3, what is being searched? Depending on whether the school is searching a locker, backpack, or clothes, it needs to comply with different requirements. And 4th, the person doing the search. Different rules apply to the search depending on what it is being conducted, if the search is being conducted by a teacher, a principal, a school resource officer, or a police officer. So there are several types of school searches. First one that we're going to talk about are strip searches. So one of the most invasive searches performed at school, and it is often conducted illegally. For such a search to be permissible, evidence must show that dangerous or illegal items are hidden. Suspicionless strip searches are almost always illegal, and schools can pay hefty settlements for violating rules. One court case that has to do with strip searches is the Safford Unified School District versus Redding in the U.S. Supreme Court 2009. Another type of school search is searches of outer clothing and pat-downs. Legal standards for pat-downs in school are unclear, especially since many researchers refer to as pat-downs are actually partial strip searches. It is therefore unclear whether random pat-downs of students that only involve outer clothing are actually illegal. Successful challenges of pat-downs usually happen when, one, the school official groped the student during the search, or two, did not have reasonable cause to do the pat-down of the student. Another type of school search is a video recording. Schools cannot record students without their knowledge while changing in a locker room or restroom. Because students have reasonable expectation of privacy in changing rooms, such searches are considered illegal. Another court case involving a video recording is Branham versus Overton County School Board, Sixth Circuit Court of Appeals. Another type of school search are personal belongings. School officials only need reasonable suspicion that there is a crime before searching a student's belongings. School administrators do not have to have a search warrant or a probable cause before conducting a search because students have a reduced expectation of privacy when in school. And that, I think, the personal belongings is the most type of school search that we see. And it's interesting that school administrators do not have to have a search warrant or probable cause. But if it was a police officer or an SRO doing the search, they would have to have a warrant or probable cause to search the student. Ashley?
Okay, there's more types of school searches. Student lockers. The federal law allows locker searches because lockers are considered school property, and students shouldn't expect anything they put in there to be kept private. This pertains to other school property, such as desks. Also, metal detectors. Schools need reasonable suspicion to single out a student with a metal detector that they are allowed to search the school premises with a metal detector or randomly select students with a metal detector without cause. A metal detector search is often considered a body search, but it is also considered minimally intrusive. Also, cell phone searches. That's conducted only when there is a reasonable suspicion. So there's also social media accounts. School administrators and teachers cannot force a student to give their password to a social media account. SS versus Minnewaska Area School District. That's in District Court of Minnesota, 2012. Drug sniffing dogs. Random searches are legal in schools because students in schools have no reasonable expectation of privacy. Drug and alcohol testing. A drug test usually administered by obtaining a urine sample, or alcohol tests usually administered through a breathalyzer, both qualify as a search under the Fourth Amendment. If a student is noticeably impaired and has alcohol on his or her breath, school officials would have a reasonable suspicion to conduct a breathalyzer test. Also, noticeable impairment combined with information received from a credible source about the same student's recent consumption of drugs or alcohol would likely constitute a reasonable suspicion. However, a student's misbehavior alone would not justify drug alcohol testing if there were no other indicators that the student was using drugs or alcohol. Some of the questions that are asked, what constitutes an illegal search and seizure? Generally, a search or seizure is illegal under the Fourth Amendment if it happens without consent or warrant or a probable cause to believe a crime has been committed. What is required for a search warrant? A valid search warrant must be filed by a law enforcement officer in good faith, based on reliable information that shows probable cause to search. Plus, the warrant must be signed by a judge and specifically state the place they intend to search and what items they are looking for. If the police has a warrant, can they search wherever they want? No, police can only search the area listed in the search warrant. For example, if they had a warrant to search your car, they could not also search your home. However, they can search outside the scope of the warrant and seize other items if they are in plain view. They can also act to prevent the destruction of evidence.
So to summarize our presentation, the Fourth Amendment protects people from illegal search and seizures by the government. Public schools need reasonable suspicion to search a student. And in a public school setting, administrators have greater leeway to search a student than an SRO or a police officer. This concludes our presentation. on the Fourth Amendment and search and seizure.